All right. I will call this meeting of the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Harris, Senator Dondale Loop, Senator Orenshaw, here. Senator Wynn, here. Senator Hansen, here. Senator Krasner, here. Senator Stone, Chair Scheibel.
Who aren't here yet present when they arrive. And we are going to go ahead and get started just so that you guys all know what's going on today. We just came off the floor. We're going back to floor immediately upon the adjournment of Judiciary, so that's why we're moving at a strong clip today. The Assembly is still on the floor. The presenter on our second bill is Speaker Yeager, so hopefully we'll wrap up AB 51 just in time for our presenter to get here on AB 291. And with that, I will open up the hearing on AB 51.
Good afternoon, Chair Scheibel, members of the Senate Committee on Judiciary. Mike Morton here for the Office of the Attorney General. With me today to present AB 51 is John Jones. And we do have an amendment to the bill that we will discuss after the presentation on the first reprint of AB 51 as written. And with that, I'll turn it over to DA Jones.
Thank you, Chair Scheibel, members of the Senate Judiciary Committee. My name is John Jones, and I'm here on behalf of the Nevada District Attorneys Association. I want to start off by thanking Attorney General Ford for sponsoring AB 51, and we also want to thank Chief of Staff Benitez Thompson for setting up a working group on this bill. The bill before you is a compromise piece of legislation resulting from a stakeholder group put together by the Attorney General's office. The stakeholders included the Attorney General, Nevada Coalition to End Domestic and Sexual Violence, the public defenders, law enforcement, and others. There are three major components to AB 51. The first component gives law enforcement up to 7 additional days to effectuate an arrest for battery domestic violence when the alleged perpetrator is not at the scene of the initial call. Additionally, it cleans up an enhancement for when a crime is committed while under a protection order. And finally, it makes domestic violence non-probationable again. So turning to the first section, sections 1, 2, and 3, those sections again give law enforcement up to 7 days to effectuate an arrest for battery domestic violence. Under current law, when law enforcement responds to a domestic violence call, they must arrest the perpetrator within 24 hours after the incident if they have probable cause. However, when the perpetrator has fled or otherwise cannot be located, officers only have 24 hours to locate them, or they have to seek an arrest warrant for anybody who they did not catch within that first 24-hour period. So, for example, if an alleged perpetrator shows back up at the victim's residence at hour 25 after the incident, law enforcement cannot effectuate an arrest and must instead submit for an arrest warrant. By their very nature, the arrest warrant process takes time. We've got to finalize all the reports and get photographs, 911 recordings, and witness statements from law enforcement, who then gathers and seeks this information and gets it to the prosecuting agency, be it the city attorney or the DA's office. Once we get it, we review it to determine whether or not we're going to seek a prosecution. And once we approve a prosecution, we then submit it to a judge who reviews all this information prior to deciding whether or not to actually issue the warrant of arrest. Once a judge makes that decision, it is then sent back to us and law enforcement for entry into the warrant databases. And as you can imagine, this all takes time. And with domestic violence, the earlier we intervene in these cases, the better the outcomes. Now, domestic violence calls are high priority, and they will remain high priority under AB 51. Our goal with this bill is not to alter in any way law enforcement's obligation to arrest a alleged perpetrator for domestic violence when they are located at the scene or within the current 24-hour window. But again, it is not unusual for suspects to flee, and in those instances, this portion of the bill will give law enforcement up to 7 additional days to locate the alleged perpetrator, thereby avoiding the cumbersome arrest warrant process. Now, I do want to say in reviewing the bill, we have spoken to law enforcement and public defenders, and that we do feel we can tighten up the word encounter. Right now, it says if law enforcement encounters the alleged perpetrator, then we do not get the 7 days. So we're going to try to work and tighten up the word encounter. So I would anticipate a proposed amendment once we work with the stakeholders on tightening up that language. The 2 remaining sections of this bill are Section 14 and Section 16, and both of these sections are cleanup measures. Section 14 amends NRS 193.166. If somebody commits a felony and they're committing that felony while they're in violation of a protection order, current law says they can be punished by an additional 1 to 20 years. However, if the underlying crime is punishable as a Cat A or B felony, our most serious felony, the person must additionally be punished by imprisonment for a minimum term of 1 to 5. So it's clearly flipped in statute. It should be 1 to 5 years if it's a category E, D, or C felony, and 1 to 20 years if it's a category A or B felony. This is similar to other criminal enhancements that we have, and this bill makes that technical correction. And finally, Section 16 makes felony domestic violence non-probationable again. Last session, the legislature passed AB 42, and this bill was amended a few times as it progressed through the legislative process. During some of the final amendments, the language was changed that inadvertently made felony domestic violence probationable. This was not listed in the title of the bill, and it was not discussed at all during legislative testimony. In other words, it was an inadvertent mistake. So this bill would fix that error created by AB 42. I do want to note that felony domestic violence has always been non-probationable, and Section 16 would return that language into statute. With that, Chair Scheibel, I'm available to answer any questions, and I know Mr. Morton did want to talk about the proposed amendment to AB 51.
Thank you again. Mike Morton for the record with the Attorney General's office. At this time, with your indulgence, Chair, I'd like to invite up Serena Evans to sort of walk you through the specifics of the amendment. But as to the logistics of the amendment, in last week's deadline week, there were some inadvertent pieces of provisions of certain pieces of legislation that were left out of bills, and this seeks to remedy that. And so the amendment that you see before you that we submitted yesterday provides, clarifies what the privilege for victims advocates of human trafficking and domestic violence. You will see that on proposed section 3.6 and 3.8. The meat of the amendment, however, is the proposed new language in section 3.2, which delineates the types of training that is required for victim advocates to take in order to be able to avail themselves of the privilege that you see on the second page. And with that, we're happy to answer any questions.
We're going to invite Ms. Evans up to briefly speak to the amendment if there's anything you want to add or clarify.
Thank you, Chair. Serena Evans, Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. Yeah, did a good job clarifying it. I think essentially just the genesis of this amendment and what's being proposed is to professionalize victim advocacy. We've heard from victim advocates around the state that when they do get subpoenaed to court, there's sometimes questioning of what training they've gone to in order to be able to claim privilege. And so this is the first step in professionalizing victim advocacy, clarifying what training they go through as a way to prove that they, are good stewards of privilege and confidential communication and things like that. So.
Excellent, thank you. Questions from members of the committee? Senator Wynn.
I just have one. You had discussed about how burdensome and time-consuming it was to obtain arrest warrants. And I was wondering if you could speak to what the length is of time is and where those holdups are coming from. I'm assuming those arrest warrants are generated from the police officers that respond to the initial call. But I was wondering if you had more on that.
Thank you. John Jones on behalf of the Nevada District Attorneys Association. We can expedite arrest warrants, especially in certain situations, but we're still dealing with, at a bare minimum, days. So what we require in terms of our office, in terms of an arrest warrant packet, is all of the declaration of arrest, all witness statements, make sure body cam footage is uploaded, and anything else we would need to prosecute the case. Once we get that case from law enforcement, we then review it for a charging determination. Once that charging determination is made, it then goes to our secretaries to type up the proposed criminal complaint. Once that is done, it is then sent to the judge's chambers. And from that point, it is out of my agency's control. It's up to the judge how quickly they get that turned around. Once the judge has reviewed it and agreed that, yes, an arrest warrant should issue, we would get that back, and then we would enter that into the system. So we're talking generally days, but on average, it's about a 30-day process.
Sorry, I was taken aback. I wasn't prepared for you to say 30 days. That seems like an incredibly long amount of time for to do that. And then do we have any information about once that arrest warrant goes actually into the system, whether or not someone is arrested on that? Because, I imagine that there are so many of these domestic violence arrest warrants, unfortunately, that how many of them just go into the system and how many people are actually being pursued on those arrest warrants?
John Jones on behalf of the Nevada District Attorneys Association. Senator Wynn, that's actually a great question. I do not have those stats, but I can tell you right now, the largest chunk of our misdemeanor arrest warrants are battery domestic violence. So our hope is that this will take some of those out of the arrest warrant category, place them into the arrest category, and our process is designed to move faster with arrest. That's how the process is designed. So we're hoping that we'll get people more stabilized in their domestic situation. We'll get batterers into treatment faster and hopefully lead to better outcomes.
And I just wanted to also point out that I'm happy to see some of this amended training language be revived in this bill. So that's exciting to see.
All right, Vice Chair Harris.
Thank you, Chair Scheibel. Can you explain why you have to get an arrest warrant in the first place under current law?
John Jones on behalf of Nevada District Attorneys Association. Nevada law limits when an officer can arrest an individual based on a misdemeanor offense. Now, battery domestic violence under current law is excepted from the arrest prohibition for misdemeanors. In other words, an officer can arrest somebody accused of battery domestic violence for which there's probable cause up to 24 hours after the incident. So if an officer comes across somebody who they have probable cause has committed battery domestic violence within the preceding 24 hours, they are authorized to effectuate an arrest on that defendant. If we are outside the 24-hour window, then the remedy is seeking an arrest warrant. And so those are the two avenues in which you start a case when somebody is accused of battery domestic violence.
So, if I'm understanding you correctly, it's because this is currently a misdemeanor and our law already has a limit on when you can arrest someone on a misdemeanor without an arrest warrant. Is that right?
John Jones, on behalf of the Nevada District Attorneys Association, with respect to battery domestic violence, that is correct.
Okay, thank you.
Other questions from members of the committee? I also have a couple of things I wanted to clarify on this, that number one, we are talking about misdemeanor domestic violence because felony domestic violence, technically, an officer can arrest with only probable cause, as opposed to a misdemeanor where it has to be committed in the officer's presence. So, if we have a felony situation where a perpetrator has fled the scene and then comes back at the 26th hour, but the same officer happens to be on duty, happens to be available, that officer is still authorized to go arrest the person at any point with probable cause on a felony domestic violence, right?
John Jones, on behalf of the Nevada District Attorneys Association, that is correct, and I'm sorry if I confused that issue.
And the other thing I wanted to ask about, and I will first apologize for not having a chance to meet with you before the hearing about the bill, but I would be interested in, on page 4, I don't know what section we're in, down at the very bottom on lines about 43 to 45, that's the 12-hour cooling off period. And what my experience has been as a practitioner is that when people are arrested on the scene, like that within 24 hours, the 12-hour cooling off period makes sense. If they're arrested 4, 5, or 6 days later and still have to do the full 12 hours, one of two things happens. Either they're released before the 12 hours is up, so then they have to come back and serve it later, or that 12 hours escalates the problem because now they've missed work another day, they've been incarcerated 4 days after the incident has mostly concluded. And so I'm wondering, you guys don't have to answer right now, but I wanted to get on the record that I'd be interested in seeing an amendment that kept the 12-hour cooling off period for the arrest within 24 hours, still allowed the arrest within 7 days, but didn't require the 12 hours if the arrest was more than 24 hours after the incident.
John Jones, on behalf of the Nevada District Attorneys Association, that's actually a great point that has not been brought up before, but I understand exactly what you're saying, and I'll work with the public defenders and others on an amendment.
Serena Evans, for the record, I know that 12-hour period is really critical in order to serve emergency protection orders, and so we need to walk that fine line of making sure that there's ability to serve the perpetrator with protection order, as well as, walking that fine line of not holding someone longer than we need to. So I think we're open to working on that language.
So, Vice Chair Harris.
Thank you, Chair Scheibel. Sorry, I'm thinking through this as we're going through the hearing. Why is it so important to keep this as a misdemeanor? If we got rid of that, that also solved the problem you're looking to solve, yes?
John Jones, on behalf of the Nevada District Attorneys Association, are you talking about increasing it to another level of offense, a gross misdemeanor? Or making it a felony?
So my understanding is that the real problem is that when a misdemeanor is committed, you have to catch them in the act, but we've given you 24 hours when the misdemeanor is battery domestic violence. Why not just up the charge and then problem solved, yes?
John Jones, on behalf of the Nevada District Attorneys Association, there have been prior efforts at the legislature to raise the penalty for battery domestic violence. If that is a conversation you're willing to have, we are willing to engage in it, but I'm not prepared to take a stand on that at this time.
Yeah, and I know that's not what this bill does, but it seems like that's actually the problem you're trying to solve. It's not like other misdemeanors, which is why you want to be able to have a longer period of time, and we're doing all this dancing around it, when it seems like I don't know why we would want to work so hard to keep it as a misdemeanor. But that's just, I guess, a little commentary. I'd be willing to entertain an amendment that just fixes it.
I think historically, DUIs and DVs have always been treated differently. They're the only enhanceable the two enhanceable misdemeanors that I've ever encountered. There may be others. And so that's kind of a long-standing tradition in Nevada law to treat DV and DUI differently from other misdemeanors. Senator Orenshaw has a question.
Thank you, Chair. And I think my question's for Mr. Jones. On section 16, page 12 of the bill as amended in the Assembly, the language deleted at subparagraph 11 regarding the diversion court for veterans and members of the military. I'm trying to make sure I understand this correctly. That would still potentially survive if it's offered, or would this be done away with? Thank you.
John Jones on behalf of the Nevada District Attorneys Association. That is a great question. Battery domestic violence defendants are now allowed into misdemeanor veterans court programs or the like, or similar programs. If they're not, if the justice court doesn't have them, they can transfer to the district court. This would not change that. Felony domestic violence are not eligible for the program because it is non-probationable. So this would not change anybody who is eligible for those programs who are currently eligible.
Thank you, Mr. Jones. I may have a brief follow-up. And so that ineligible, I appreciate you clarifying that for me, that the Veterans Court would still exist for the misdemeanor charges. The prohibition then on the felony domestic violences, would that apply to whether it's a third offense in 7 years that makes it a felony, or whether it's a felony strangulation, felony with substantial bodily harm, all the felonies across the board, or, thank you.
John Jones on behalf of the Nevada District Attorneys Association. All felony battery domestic violence would be non-probationable. So that would include domestic violence battery third. So that means it's your third conviction within 7 years. Battery domestic violence strangulation, battery domestic violence substantial bodily harm, all of those would remain non-probationable.
Thank you, Mr. Jones. Thank you, Chair.
Senator Stone.
Thank you, Madam Chair. Mr. Jones, are there any gross misdemeanor crimes for battery domestic violence?
John Jones on behalf of the Nevada District Attorneys Association. There is a battery domestic violence on a pregnant person, I believe, is a gross misdemeanor.
Okay. And how would that be handled under this bill?
John Jones on behalf of the Nevada District Attorneys Association. Since that is a gross misdemeanor, this would not change anything with respect to that charge.
And what is the period of time that an officer can arrest a person allegedly causing that kind of a crime?
John Jones on behalf of the Nevada District Attorneys Association. If I'm not mistaken, any time within the applicable statute of limitations period, and on that offense, I believe it's 1 year.
Any other questions? All right. Thank you all so much for joining us. At this time, we will move to testimony in support of AB 51, starting with anybody present in Carson City or Las Vegas. Come on up to the table. You'll each have 2 minutes, and you can begin whenever you're ready.
Thank you, Chair, members of the committee. For the record, Mike Cathcart, representing the City of Henderson. Just want to thank the Nevada District Attorneys Association for all their work on this bill, and we are supportive. Thank you.
Hi, Liz Ortenberger for the record. I'm the CEO for Safe Nest. We work with over 20,000 clients, abusers, and children affected by domestic violence and sexual violence every year. Thank you to the AG's office for bringing this bill forward. What we see on the ground, because we respond on scene with Metro for any calls in which there is an arrest or probable cause for an arrest, is batterers flee about half the time. It is one thing to hide for 24 hours at a buddy's house. It is another thing to hide for 7 days, and they do hide. We like the language of this bill, and we are in support. In answer to Senator Scheibel's question about the ETPOs, it's critical that it is 12 hours. We process all the ETPOs for Clark County. Family court takes a minute, the jails take a minute, and the survivor is not alerted when they are arrested on warrant, when they are arrested. So if they're arrested at another location, it takes a while to coordinate the process for an ETPO. So that 12 hours is critical. Thank you.
Nix County, City of Reno. I'd just like to echo the comments from the City of Henderson and appreciate the bill sponsors' work on this measure. Thank you.
Good afternoon, Chair Scheibel, members of the committee. Jason Walker, Washington County Sheriff's Office. Glad that I was able to participate in the working group on this and happy to see it come forward, testifying in support of AB 51.
Good afternoon, Chair Scheibel and the committee. My name is Beth Schmidt, SCHMIDT. I'm with the Las Vegas Metropolitan Police Department. We do support this bill. We want to thank the AGs and the district attorneys and everybody that was brought to the table. There was a lot of work that was put into this. Also really do appreciate bringing the language in from the amendment of professionalizing the victim's advocacy. We are in firm support of extending that arrest window to 7 days.
Good afternoon, Madam Chair, Committee. I'm Zach Bucher with the City of Las Vegas. Ditto to all the previous comments. We're here in support. It's a good bill, and we appreciate your time and consideration. Thank you.
All right, I don't see anybody else coming up to give support testimony in Carson City or Las Vegas, so we'll move to opposition testimony in Carson City or Las Vegas. Oh, I forgot the phones. We will go to the phones for support testimony on AB 51.
Who would like to testify in support of AB 51, I'm sorry. So please press star 9 to take your place in the queue.
Good afternoon, Chair Scheibel and members of the committee. For the record, my name is Pamela Del Porto, and I'm the Executive Director for Nevada Sheriffs and Chiefs Association. I'm testifying today in support of AB 51, and we want to acknowledge and say thank you to all of the people that worked on this bill, including the Nevada District Attorney's Office, the Attorney General's Office, and the other stakeholders. Thank you so much.
Hi, this is Kathy McKenna. I'm the Executive Director for No to Abuse Nevada Outreach Training Organization located in Pahrump, Nevada. We cover the 5th Judicial District in Nye and Esmeralda counties. Much like Safe Nest, although we're much smaller, we serve several hundred victims of domestic and sexual violence in our community. We are in support of AB 51, both for the extension in time as well as the advocate training that we go through. And on the extension of time, it is very important for us because we are in the process right now of having difficulty obtaining TPOs and EPOs from our justice court judge. So that extension of time will greatly help us in our community. Thank you.
That concludes our callers testifying in support.
All right, now we will move to opposition testimony for anybody here in Carson City or down in Las Vegas. But not seeing anybody, we will go to the phones for testimony in opposition to AB 51.
If you would like to testify in opposition to AB 51, please press star 9 to take your place in the queue. We have no callers to testify in opposition.
All right, then we'll move to neutral testimony. Anybody wishing to testify in neutral is invited to the table in Carson City or Las Vegas. But not seeing anybody, we will go to the phones for neutral testimony.
If you would like to testify in neutral for AB 51, please press star 9 to take your place in the queue. We have no callers testifying in neutral.
All right, then that brings us to the conclusion of testimony. If the presenters have nothing further, we will close the hearing on AB 51. And we're going to take a brief recess. I understand the assembly is concluding right now, so please don't go far. And we'll gavel back in a few minutes when we have our presenters here for AB 291. We're in recess. All right, we are back from recess and opening up the hearing on AB 291. Come on up and welcome to Senate Judiciary. Please go ahead whenever you're ready.
Good afternoon, Chair and members of the Senate Judiciary Committee. My name is Steve Yeager. I represent Assembly District 9, and it is a pleasure, as always, to be in front of this committee. And thank you for your patience in allowing me some time to get up here to present this bill. What you have in front of you today is Assembly Bill 291, and I promise you this is going to be a very short presentation. Essentially, what this is trying to do is update a 20th century law to have it pertain to the 21st century in the era of internet financial crimes. The impetus from this bill was actually an individual who reached out to me who has business both in Nevada and out of state, does lending, commercial lending online. And what was happening to him was the loan would originate from, say, Tennessee, and the borrower would be in Nevada and fill out fraudulent documents and submit them online. And when they found that out, they funded the loan. When they found out it was fraud, he was having some issues getting law enforcement to be interested in the case due to potential jurisdictional issues, being that the entire crime didn't happen within the state of Nevada. There was a nexus to other states. And some of you may have had this happen to you as well. I know personally I've at times had my credit card used in other states, where I'll get a notice that someone went to a Walmart in Arkansas and charged a bunch of money to my credit card, and I think that raises questions about who has jurisdiction, and I think logically so. So what this bill does, and it's pretty simple in terms of the language of the bill, in the second page of the bill, that's where the new language is. It just indicates that the state's not required to establish that all of the acts constituting the crime happened in either Nevada or in the local jurisdiction. It could be a city, for instance, and that is not a defense if some of the acts occurred outside of the state. Now, I will tell you there are some laws already in place that include this language, but the problem we were having is we want to put this language actually into this specific NRS so it is clear both to law enforcement in making the arrest and filing the report, and to our prosecutors that you don't have to go look somewhere else in the law. It's very clear here that if any of the crime happened here in the state of Nevada, that they would have jurisdiction and be able to prosecute it. Now, I will tell you, there's always going to be some logistical considerations. Law enforcement has limited resources, so they're going to prioritize, like they always do, about what they're going to prosecute. But in the right case, I think this would give them some assurances that they could initiate a case here in Nevada, and it wouldn't be a defense for someone to come in and say, well, that didn't happen here in the state. As an initial matter, they're going to have to get actual jurisdiction over that person, so they're going to have to make sure that they're either in Nevada, the defendant that would be either in Nevada, or they're arrested and extradited here for that prosecution to happen here. So I did have some individuals who testified in support and helped me present in the assembly side. I spared you that because I know it's a strange couple of weeks and I don't want to make people wait on Zoom and all that, but I'm happy to answer any questions, and I do believe I have some folks who will come up in support from law enforcement and prosecutors that hopefully could help answer questions as well. But it has been a pleasure to present this to you, and certainly would be happy to try to answer any questions you might have.
Thank you so much. Any questions from members of the committee? I don't see any. I have one, though, because I am familiar with this language in other statutes, and I'm hoping that you can just help us understand what kind of double jeopardy protection exists so that one person isn't being prosecuted for the same crime both here and in another state at the same time.
Steve Yeager, for the record. That's a really, really good question that legal counsel would be good to answer. But no, I mean, generally there's a double jeopardy protection, but I think, what you'd have is there would likely be a coordination, right? The states would probably decide, but there's double jeopardy should apply on the state side. Now, if you commit a crime and it's also a federal crime, you're not protected from double jeopardy federally. So in the example I gave you, that's mortgage fraud, you really could be prosecuted by both jurisdictions. But usually in our state, there's a coordination between our local offices and federal prosecutors to decide who's going to take that case. And as you're well aware, it's a lot harder to get the federal government to be interested. And in fact, that was some of the testimony from one of my co-presenters. His issue was some of these loans are very small loans, so he would report them federally. And unless you were talking in the millions or tens of millions of dollars, it was just just something that the federal government and federal prosecutors weren't going to get interested in. But yeah, all those normal rules about double jeopardy would apply, so I don't think we'd be in a situation where someone would be prosecuted twice. The states would have to coordinate to figure out where that was going to happen. And truthfully, it's going to probably happen where they find the defendant, right? In my example, if the defendant gets arrested in Tennessee, they're probably going to prosecute. If it's in Nevada, they're probably going to prosecute. But they're not going to have the issue of saying, well, we don't know who has jurisdiction here and who can rightfully prosecute.
Thank you. That answers my question. And I don't see any other questions. So we will move to testimony in support of AB 291. Anybody wishing to testify in person is invited up to the table in front in Carson City and Las Vegas.
Good afternoon again. Chair Scheibel and members of the committee, my name is Beth Schmidt. I represent the Las Vegas Metropolitan Police Department. Prior to my assignment in intergovernmental services, I spent 3 years in financial crimes. And I can tell you that this bill is terrific. We really, really like it. Nationally, keep in mind that Nevada is number 3 for fraud, and it's number 5 for ID theft. And a lot of that is done online. And this gives us the ability to investigate those crimes. And we are very, very appreciative that Speaker Yeager brought this forward.
Thank you, Chair Scheibel, members of the Senate Judiciary Committee. My name is John Jones here on behalf of the Nevada District Attorneys Association. We're also in support of the bill and want to thank the Speaker. Thank you.
All right, I don't see anybody else present to give support testimony, so we'll go to the phones for testimony in support of AB 291.
If you would like to testify in support of AB 291, please press star 9 to take your place in the queue.
Good afternoon, Chair Scheibel and members of the committee. For the record, this is Pamela Del Porto, Executive Director for Nevada Sheriffs and Chiefs. We are also in support of this bill and appreciate Speaker Yeager for. Thank you so much.
There are no further calls testifying in support.
All right, then we'll go to testimony in opposition here in Carson City or down south in Las Vegas. But I don't see anybody, so we will go to the phones for testimony in opposition.
There are no callers testifying in opposition.
Okay, then we'll go to neutral testimony. Anybody here in here in Carson City, down in Las Vegas for neutral testimony? Not seeing anybody. Let's go to the phones for neutral testimony.
There are no callers to testify in neutral.
All right, then that brings us to the conclusion of testimony. Unless the sponsor has any further comments, we will close the hearing on AB 291 and go to our last item on the agenda, which is public comment. Thank you so much for joining us. Anybody wishing to give public comment is invited up to the seats in the front of the room in Carson City or Las Vegas, but I don't see anybody, so we'll go to the phones for public comment, 2 minutes per caller.
There are no callers to testify for public comment.
All right, then that brings us to the conclusion of our meeting. Same drill tomorrow. We do have 2 bills on the agenda. We're all going to have to be flexible with the timing, and until tomorrow, we are adjourned.